But thank you for joining and welcome to our February webinar, which is about the new sexual harassment laws, specifically on prohibition, positive duties and stop orders. Again, we have a lot to cover, so I'll be speedily working through the content. But if you do have any questions or want any extra resources, then please send us a message and we would be happy to help. So the webinar will go for about 30 to 40 minutes. And the topic is on the screen just here. For those who don't know me, my name is Claire Harrison. I'm the Managing Director of Harrison's. We're a HR consulting and outsourcing firm. A little disclaimer to get started. We're not lawyers. We're not giving individual legal advice. So that's our disclaimer page. A little bit about Harrison's. So Harrison's has been around for 14 years now. We have 4 key areas of service, firstly being consulting. That can be anything from compliance work with contracts and policies, right through to organisation restructures, delivering training courses, whatever that might be across the consulting area. Second service is our HR team service, which is really suitable to an SME type client. We call it an outsourced, insourced service where we go in, do a health check, develop a plan, and then have someone on site to deliver on that plan. Thirdly, we do offer a recruitment and onboarding service. And lastly is our myhrexperts.com.au, which is an online membership subscription service where you get access to a huge amount of e-learning courses, templates, content for you to meet your HR work health and safety, compliance and other needs. So we will have our contact details at the end as well. This is just a little image of our team and all the people that we have working with Harrison's, based at our East Brisbane office in Brisbane. Okay, but importantly, in terms of today, we're talking sexual harassment, which, you know, is an old topic for those of us that have worked in HR. There's been legislation around it for many, many years, but there has been some changes and it's important that you're all up to date with what they are. So we're going to talk about what those changes are and why the changes have been made as well. So what the impetus to the change has been, what the changes mean for employers, defining sexual harassment, which really hasn't changed for those that have been working with the definition. The new, importantly, positive duty on employers, vicarious liability for employers, and we'll talk about some strategies for employers to mitigate risks to ensure they're complying with the new legislation, creating a speak up culture, and a little bit on support and resources at the end. So I will move through that, but to start with, I'm just going to put some stats up. So many of you would know the Australian Human Rights Commission conducted a piece of work which is called Respect at Work, which is a report that a lot of these actions have come from. But from that, this is from back in 2018, they gathered a rich collection of data on the experience of sexual harassment of Australians aged 15 to 65. So there's some information up there. So, and the data is broken down by the forms of workplace sexual harassment that it can take, who the harassers are, who is being sexually harassed at work, workplace industries and settings that have a high prevalence of workplace sexual harassment, and who witnesses sexual harassment. I will say, just in case I forget to say it later on, the Australian Human Rights Commission has created this website, Respect at Work. It has a huge amount of information and resources that would be really useful for all employers. So I suggest that you have a look at that as well. Some other statistics, which, you know, just tell us that sexual harassment, although we do have legislation that exists around it and current avenues, it continues to dominate workplaces. And then also from the Respect at Work research is the cost of an estimate of the cost of workplace sexual harassment in Australia. So that's just setting a bit of a scene, because that will explain, I think, some of the reasons why the changes have been made. So, like I said, there was a report conducted. So it was carried out by the National Human Rights Commission. It was an inquiry into sexual harassment. There are a huge amount of recommendations, 55 of which the current federal government has made a commitment that they will action in entirety. So that's where the legislative changes that we're talking about have come from. So basically what it says, everyone has a role to play in preventing workplace harassment. The research has shown that really the onus has been on the person being harassed to defend themselves and take it further. So what we're trying to do, what the legislation is trying to do, is balance that responsibility of everyone in the workplace to stop workplace harassment from happening. What they did find, and I'll talk about a little bit later, is that really gender equality and power imbalance are the major underlying reasons of sexual harassment at work. So the inquiry involved, a huge amount of research looking into the systematic sexual harassment in Australian workplaces, and came up with these recommendations. Again, this report in its entirety, for anyone who wants to read it, is available on the Respect at Work website. But what it did come up with specifically for workplaces is a prevention framework, which talks about, starting with leadership. It needs to come from the top and the leaders from the organisation. Risk assessment, creating that culture, ensuring everyone has the knowledge that they need to prevent sexual harassment, supporting people that are experiencing or that need help in the area, the reporting and measuring components, but it's really about the prevention rather than getting to the point that they're dealing with the complaints that are being made. So this, again, is available on the Respect at Work site, but we will, in our strategies, talk about some of these different areas that need to be covered from a workplace perspective. So we talked about the causes of workplace sexual harassment. I just mentioned that the research did show that it's due to power imbalance, which is predominantly through gender inequality. So the unequal distribution of power, resources, opportunity and value afforded to people in a society based on their gender. So that continues to be the case. It's definitely continues on. Sexual harassment is considered a form of sex discrimination and gender-based violence. It can be experienced for everyone, transgender, gender diverse, not as much research around that as well. And it is higher in those areas though compared to against men. As a group, these people have significantly less economic security, seniority and influence than men. In the workplace, as in society, the balance of power resides with men. This is taken from research, and based on the research, these are the underlying causes of workplace sexual harassment. So gender inequality begins outside of the workplace and plays out in our society through our attributes, beliefs, and our behaviours. So again, I'm talking about this because the current government and the research is using this as the foundation for a number of changes that have been made to workplace relations type legislation. Of today, we're focusing on sexual harassment, but we do know that the some of the other changes to the Fair Work Act have been around things like equal pay and reporting around that, and removing pay secrecy so we can discuss pay. Okay, so as a result of that report and the research and the commitment the current government has made, there are a number of changes that are going to be made or have been made, majority have been made, to legislation. So just to cover the sexual harassment laws in Australia, there's a number of them. So the main federal piece is the Sex Discrimination Act, and the top two I've got in red because we're going to talk more about them and the changes that have been made. Now the Fair Work Act specifically, didn't previously mention, but now it does specifically talk about it. State and territory, anti-discrimination, EO and human rights laws, Commonwealth, state and territory work health and safety laws, and we will touch a little bit on work health and safety laws, Commonwealth, state and territory workers' compensation laws, criminal law, and the Convention of the Elimination of All Forms of Discrimination Against Women. So that was that is with the United Nations, and that was entered into by a number of organisations back in 1981. So that global commitment to create safer and more respectful workplaces for women specifically. So that's the legislation that currently, and we'll cover sexual harassment. So not just one, there's a few that we need to think about. Okay, and I thought I'd put this up because, we need to be clear on what we're talking about. So this is the definition that currently exists within the Sex Discrimination Act. The Fair Work Act and the Work Health and Safety Act will also reflect that same definition. So that hasn't changed. I'm not going to go through that in detail because I'm more talking about the changes that have been made, but really important when you are educating leaders and employees and workers and other people within the organisation and surrounds it, we understand what this definition is, and it can be broken down further. Okay, so if we look at the Sex Discrimination Act, so this come out of, in November 2022, the Australian Human Rights Commission passed through federal government the Respect at Work Bill, the Respect at Work Act now. It's a milestone in addressing workplace sexual harassment in Australia. The new Act creates a positive duty requiring employers to implement measures to prevent sexual harassment, sex discrimination and victimisation, and gives the Commission, the Australian Human Rights Commission, additional powers to be able to govern those new pieces of legislation. The positive duty, so we're going to talk about positive duty, was a key component to the recommendations that came out of the Respect at Work report. Like I said, the Act, there's 55 recommendations, and this new amendments to the Sex Discrimination Act implements 7 of those actions that were recommended. And so would significantly strengthen the legal and regulatory framework surrounding the prevention of sex discrimination in the workplace. So if we go through the key points, so the positive duty, so coming from the new Act that's was approved at the end of last year. From that, there's changes being made to the Sex Discrimination Act specifically and other changes, but we're talking about the Sex Discrimination Act specifically. So the positive duty, so the new Act inserts new provisions in the Sex Discrimination Act that introduce a new positive duty on all employers and persons conducting a business or undertaking. So some of you have probably heard that definition of PCBU that sits within our work health and safety legislation. So it's a broader definition in terms of, and they're also using the word worker rather than just employee. So again, that has a broader definition that we'll talk about a little bit more. So to eliminate unlawful sex discrimination, including sexual harassment, victimisation, hostile work environments. So that's the positive duty. So it means employers actually have to take proactive steps to eliminate sexual harassment in their workplaces. So that's important to understand for all employers. Secondly, we look at this hostile work environments. The Act also inserts a new provision in this Act that prohibits conduct that subjects another person to a workplace environment that is hostile on the grounds of sex. The Act provides that a person subjects another person to a workplace environment that is hostile on the grounds of sex if a reasonable person, having regard to all the circumstances, would have anticipated the possibility of the conduct resulting in the workplace being offensive, intimidating, or humiliating to a person by reason of the sex of the person or a relating characteristic. And there's a number of circumstances to be considered, but that is about putting that onus back on the employer to be creating a non-hostile work environment. So not even a specific complaint, but that responsibility of creating an environment that doesn't have sexual harassment or sex discrimination in it. So that's new, the hostile working environment. The third point here is the changes to the powers and functions of the Australian Human Rights Commission. So it's also given them a number of powers. That could be around publishing guidelines that provide directions or guidance in terms of what employers or others should do in regard to that positive duty. They can also make inquiries into and issue compliance notices, positive duty compliance. They can also apply to the federal and family courts for orders directing compliance with those compliance notices, positive duty. So all those 3 were about the positive duty. And the last one is that the Commission, Australian Human Rights Commission, can inquire into any matter that may relate to systematic unlawful discrimination. So these are new powers on the Australian Human Rights Commission. The final one is the changes to legal proceedings. The major change under that is rather than relying on an individual to make the complaint, it can be done by a representative body. Most commonly, we would think by a union that can be done. So that is also a change. So those changes to the Sex Discrimination Act are already in effect from the end of last year. So that's the changes to the Sex Discrimination Act. I just wanted to touch on work health and safety laws because as much as it hasn't changed, I think it's important to understand the definitions that exist under work health and safety laws because there already is a positive duty under work health and safety laws. But importantly, both the Sex Discrimination Act and the changes we're going to see to the Fair Work Act and talk about next use the definitions generally that sit under the work health and safety legislation. So they're talking about PCBUs instead of just employers. They're also talking about the responsibility of officers, but more, of a consideration is workers. So they are talking about a worker rather than employee. So a worker can be broader, including contractors, volunteers, other people that exist on the workplace. And it does also cover all of the legislation we've talked about. It stretches to customer and clients as well. Okay, so next we're going to move on to the Fair Work Act. So you've probably all heard, and my topic last month was the Secure Jobs, Better Pay legislation that we spoke about. So that has come into existence. Some of the changes are staged. In the case of this prohibition on sexual harassment, which is the major change to the Act, to the Fair Work Act around sexual harassment, that will be effective from the 6th of March 2023. So important to remember that. So it is about expressly prohibiting sexual harassment in connection with work. The new provisions enable harassed workers, unions, and the Fair Work Ombudsman to obtain compensation, financial penalties, and other orders against perpetrators of sexual harassment and businesses who do not take reasonable steps to guard against the risk of sexual harassment. So again, the extension of the powers and the compliance requirements and the proactive steps required by employers. The new provisions implement recommendation 28 of the Respect at Work report that recommended that the fair work system be reviewed to ensure and clarify that sexual harassment using the definition in the Sex Discrimination Act is expressly prohibited. So that was a recommendation, it needed to be expressly prohibited. Therefore, providing another option for persons who allege to have been sexually harassed in connection with work to take action to address the harassment. Workers will have the choice to take action under the provisions of the Fair Work Act or under the existing provisions of the Sex Discrimination Act, or there's various different state-based and territory-based legislation as well. It also gives unions the right to pursue such a claim on behalf of this person or the Fair Work Ombudsman to take action if there has been a breach. So what has been said about the legislation, the rationale behind this change for including these provisions in the Fair Work Act is one of the key findings in the Respect at Work report that the current regulatory framework fails to incentivise employers to create harassment-free workplaces. Instead, our laws place the burden of addressing harassment almost entirely on the individual. So what they say is many individuals who have been sexually harassed are often discouraged from taking action to address the conduct because of that burden. The new provisions are designed to alleviate the burden on individuals having to address sexual harassment in the workplace by enabling other parties to represent them, making the allegations or otherwise take action. So the new provisions, like I say, are in effect from the 6th of March. Importantly, and the probably questions I know we've had, is the new provisions don't apply to sexual harassment of a worker if the sexual harassment occurred before the commencement date, being the 6th of March this year, or is a course of conduct that began before the commencement of these new provisions, even if that conduct continues after the commencement of the new provisions. In either of these situations, the worker would need to pursue a claim under the existing laws, including the Stop Work Sexual Harassment under the Fair Work Act that applied before the new provisions took effect. They could do it down that track. So that is the major amendment to the Fair Work Act. So just a bit further on this express prohibition of sexual harassment at work. So it's unlawful for a person, the first person, to sexually harass another person who is a worker or a person who is seeking to become a worker in a business or undertaking, or is a person conducting a business or undertaking. The prohibition applies if the harassment occurs in connection with the second person being a worker or seeking to become a worker in a particular business, or as a person conducting the business. So importantly, that includes those clients and customers, which from an employer perspective makes you really reconsider your policies and training in terms of what are we doing to create that safe workplace, preventing sexual harassment in our interactions with our clients, customers, and other external parties as well. So not just thinking about our own workforce, but how that extends out to the interactions that they're having. So again, I've already said that it's broad in terms of broadening from employee to worker in terms of that definition, as well as the PCBU. But like I said, we've put up the Work Health and Safety Act. So there's similar definitions to that. The definition of sexual harassment is the same as the one that I said before. So they're using the Fair Work Act is using the Sex Discrimination Act definition, and vicarious liability in terms of that onus on employers to do everything they need to do to prevent and deal with complaints is also similar to what already exists in the Sex Discrimination Act. I've just put this up to talk about vicarious liability, but it's not a new concept really, but it has extended into the new legislation. So it's that requirement of an employer to do everything they can to prevent and deal with complaints, knowing that they can be held liable as the company and the employer, but also that managers within the company can be held liable as well. But that's not too dissimilar from current. Okay, the other change for under the Fair Work Act is giving some more powers to the Fair Work Commission, just like we spoke about the Australian Human Rights Commission before. The Fair Work Commission also has some new powers. So they're able to deal with disputes in a similar way to what they would for a general protections claim. So through conciliation or mediation, if unresolved and parties agree and they can't reach agreement, then the Commission can settle the dispute through making orders, or which can include compensation. Enables harassed workers, unions and Fair Work Ombudsman to obtain the compensation, which I mentioned before. Workers, like I said, have the choice in terms of, and it's not one or the other, they don't replace each other. They can go to the Fair Work Commission, they can go to the Australian Human Rights Commission, or there's the relevant state legislation and bodies as well. Importantly, out of that, like I said, they have modelled this off the current provisions of the Fair Work Act about general protections, dismissal disputes, are the stop sexual harassment orders. So applications can be made to the Fair Work Commission and they can be asked to do either or both of the following. So make a stop sexual harassment order and or otherwise deal with the dispute, whichever way, by mediation or conciliation. Types of stop sexual harassment orders could include orders requiring the respondent or respondents to stop the behaviour, compliance with or development of sexual harassment policy, and the provision of information, additional support and training of workers in relation to sexual harassment. So very similar to the current workplace bullying harassment orders that we see and the changes that have been made there. I thought I would just also point out other workplace rights. So all of the Sex Discrimination Act, the Fair Work Act and Work Health and Safety laws protect workers from being punished or treated unfairly for asserting workplace rights. Employers cannot treat a worker unfairly or punish them because they've made or been involved in a sexual harassment complaint, or if they decided not to. They proposed to make a complaint, they helped someone else make a complaint, or raised an issue about sexual harassment in their workplace. So the different laws say different things, but under the Sex Discrimination Act, they talk about victimisation. Under the Fair Work Act, we have general protections, which makes it clear that adverse action and coercion aren't permitted, and similar protections exist in our work health and safety laws as well. So I thought I would just talk about that as well when we're looking at those pieces of legislation. So if we just talk about some strategies from employers and what they could be doing, I've got a number of these. And so there was a question about getting the presentation. So you can get the video of the presentation if you request it post the webinar. Okay, so obviously education, training and recruitment is critical. So we need the policies in place and the procedures in terms of what it is and how complaints are made and how complaints are managed. That needs to be, employees need regular training on that and education, and it also needs to be included in your onboarding, induction processes, and regularly reviewed. It may be applicable to conduct criminal record checks, drug and alcohol policies, especially as they relate to out-of-hours conduct and social events, are really important. So look, there's no shortage of best practices that employees can enact to carry out their positive duties. So it's thinking about, you know, doing that, I suppose, a gap analysis for your organisation. What do we need? What have we got? And what can we do to make it better? So we want to create respectful behaviours within the workplace, and not just for our employees, but as that extends to contractors and clients and others. And that's best done by having your values and behaviours that support the culture you're trying to create, because really it's all about leadership and culture and creating that right culture that doesn't tolerate sexual harassment in your workplaces. Giving KPIs to management around inclusion, diversity and gender representation, and compliance with programs for elimination of sexual harassment. But really what we want is then proactively to be exhibiting the right behaviours in the workplace that align to your values and creating an environment that doesn't have sexual harassment. Definitely looking at your pre-employment questionnaires to cover off any compliance issues, but also, again, looking at that culture fit and the types of behaviours and the people that we want to bring into our organisations. So combat silence and bystanders. So I think a really good thing to do is to be running surveys, and you could do one specifically around sexual harassment, but confidential anonymous surveys about the culture, including if workers have or are experiencing or observe sexual harassment. Ensure that you have really clear confidential avenues to address any claims. Example, speak up lines. Implement mandatory reporting of sexual harassment by managers and leaders. We often, so I'll just cover it here, is we often get the question about an employee coming to a manager or to HR for that matter and raising concerns about sexual harassment, but then saying they want to keep it confidential and don't do anything about it. You know, we have as HR and leaders and organisations a responsibility to do action, to actually do something about it. So as much, you know, we want to protect the person, but we don't want that behaviour continuing in the organisation. So that mandatory reporting, not to say that it's, you know, it still needs to be kept confidential, but needs to be happening from managers and leaders. Creating specialised teams for the most serious investigations to build confidence in the system and improve the experience for those involved. Looking at workplace investigation training for your HR people especially, or outsourcing that if you need to. Harrison's can help with your workplace investigation, both training and conducting them. Ensure victim-centric investigations, confidentiality, increased comms, support, special advice, and including ensuring you've got an employee assistance program in place. So governance is really making sure there's a system that sits around this. So responding to claims thoroughly and taking appropriate disciplinary action where it's warranted after you've done the investigation and been through your process. Treat sexual harassment as a safety issue, including risk assessments, controls and reporting. That's really important. So if you haven't already, then you do need to look at the same as what you would do for workplace bullying harassment, is you need to look at a risk assessment for sexual harassment as a safety issue in your workplace. If findings of sexual harassment are substantiated, require the decision maker to say why termination was not decided on if a lesser form of disciplinary action was taken. So if we substantiate sexual harassment definitely happened, why are you not dismissing that person? So we want to know and understand that, and there's legal considerations there. But if we're not going to tolerate sexual harassment, then we need to take a stand on it. Require executive approval in the above cases where the perpetrator was not terminated. We want to create a speak up culture so that everyone is raising concerns. So it's critical to build a culture that encourages people to report sexual harassment without fear of retribution. Psychological safety and trust underpins speak up culture. When a speak up culture is in place, leaders and teams are comfortable discussing positive and negative behaviours. They're prepared to have difficult conversations and tackle issues head on. Shared language, it's about that culture, the values of your organisation, and the behaviour that we need to be able to have those conversations, and people feeling confident and trust the process that they can speak up. These are just some points, and I've referenced where I've got these from down there, but about how to create a speak up culture. It's very much around psych safety and that inclusive culture. Training is exceptionally important. Gathering feedback, collaborating, consulting, having some systems, safeguards and policies in place. Ensure that you do something about it, ensure it's transparent, and criticise constructively. So we want to create that speak up culture. Here's just one example that you might want to have a look at in terms of that speak up culture, which may be of interest. In summary, and there's a lot on this page. So I won't go through them all, but some of these we've already spoken about in terms of your policies, your training, your induction, that meaningful consultation with your employees and your workforce and your workers about sexual harassment in your workplace and sex discrimination, what that looks like, what's happening, and then from there that you can take some actions that are meaningful for your organisation. Ensuring the complaint process is accessible, confidential, so that if there is concerns, it gets raised. Metrics, prevention measures, reporting, making sure it's topic of the agenda for your executive leadership team and for your board, because that's the way that the culture will build if we're putting the responsibility and the accountability back at senior levels. Enforcing any breaches promptly. Obviously, that regular review of policies, the types of complaints we're getting, what can we do about that? And most importantly is really fostering a respectful and inclusive culture, which obviously complies with laws, but that build that culture of trust and honesty and treating everyone with respect. And, we all say that, but ensuring that we do have processes, systems and education, leadership training in place so that actually happens. So I know we've gone really fast and we have had some questions, which I'm happy to respond to post, like I said, and you can send them to us. That's our website address, and I will give others. But if you do want, you can contact us via our Contact Us page. Is our sexual harassment workplace checklist, then please go through our Contact Us page and happy to provide that. In terms of how we can help, if you need an update on your sexual harassment policy and procedure, we do a sexual harassment workplace audit if that is of interest, as well as that anti-discrimination and sexual harassment training for leaders as well as employees and other people in the workplace, then please reach out and we can help you with that. So if you'd like to contact us, here's our details. And I thank you very much for attending. My name is Claire Harrison, Managing Director of Harrison's, and next month we'll have another webinar on a topic to be confirmed, but I thank you for your attendance today.